Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Welcome back to the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson of Battleson Law, LLC. Mark brings over 3 decades of experience across business law, commercial real estate, and deal structuring with a background that includes both legal work and hands-on business roles. I'm Lisa Mosby, and today we're talking about the restrictive covenants, including non-competes, non-solicitation clauses, and other agreements businesses use to protect relationships, confidential information, and goodwill. Welcome, Mark. Thank you so much for being with me today.
Hey, thanks, Lisa. Good to see you.
Thanks. Mark, to start at the foundation, what are restrictive covenants and why do businesses use them in agreements with employees, partners, and buyers?
Essentially, it is exactly what it sounds like. A covenant's a promise, and a restriction is a restriction on activities. So, there's in Georgia, there's a Restrictive Covenants Act that was actually went through a pretty arduous legislative and I think even a referendum process. But there were restrictive covenants in existence prior to the Restrictive Covenants Act, which I think came out in about 2011. So long story short, a catch-all of restrictive covenants is generally not necessarily confidentiality, although they're definitely a component of the agreements that are put in place. The confidentiality is more of a non-disclosure agreement, and then restrictive covenants are some restriction on activity, whether it's competition, solicitation of customers, solicitation of the employer or sold business's employees. And basically, there's value in these relationships for whomever has the relationship. And to the extent that you're going to be, they're going to expose some party to these valuable assets of theirs, including trade secrets and things like that, they want to make sure that that information isn't going to be taken by a competitor or somebody who's just looking to weaken the business through either through solicitation or hiring away key employees.
And Mark, non-compete agreements, they're just one type of restrictive covenant. What are the most common types and how do they serve different purposes in business agreements?
Yeah, so I guess a better way to distinguish between them is, whether you're an employer-employee relationship or an independent contractor working with a company versus a sale of a business or some other transaction which would warrant restrictive covenants. Non-compete, as you indicated, is truly just you will not compete with a defined term related to the type of business within a geographic area for a period of time. That's the most general way to look at it. This is America. It's capitalism. So non-competes are very disfavored in some states, California in particular, with its entrepreneurism and things like that. Employers have very limited ability to restrict employees there. Georgia, with the Restrictive Covenants Act that came into play, quite frankly, I think it came in a little sneakily where they said, I think it was on a referendum where they said, would you like there to be more jobs in Georgia? Well, what person in the population doesn't want that? Well, what it really was an ability for employers to protect their employee relationships and prevent them from going out to other competitors and taking information. That was how they pitched it, though. I remember voting on it. And so ultimately, these restricted covenants, non-compete, which are, a little bit more limited in the scope, but non-solicit agreements, which is they're far more enforceable because non-solicit means that you're actually directly contacting a customer where maybe you had contact with them and then you went to a new company and then you're taking that customer list and trying to get business away from your former employer or away from a former or away from a business that you bought. and you don't want that seller competing against you or soliciting your employees or customers. So there's a lot of different things that go into the catch-all of restrictive covenants.
And then, Mark, a lot of disputes come down to whether a restriction is reasonable. What factors usually determine whether a non-compete or similar clause is likely to be held up if it's challenged?
Yeah, so I mean, there's a long body of case law in Georgia that predates the Restrictive Covenants Act, and the Restrictive Covenants Act has case law after it came into play. But these matters don't necessarily get litigated all the way up to Court of Appeals and Supreme Court, except in fairly rare cases, given the volume of these documents out there. So the parameters generally, and again, I can't get into the details and specifics because they're very fact intensive, but for a restrictive covenant, the geographic scope can't be blanketed to the United States if the business is a local business. It needs to be reasonable with respect to geographic scope. So there isn't what's called an unreasonable restraint on trade. Trade being that your ability to go out and get another job. Or start your own business that competes with the company, but maybe not within, again, the restrictive geographic scope and the term of years. 2 years is considered reasonable. Geographic scope is much more based upon the area where you participated within a larger company or possibly the geographic footprint where this company has business. If they got one location and it's some, local business where people aren't driving more than 10 miles to go to it, then maybe a 15-mile restriction is appropriate. But larger companies with multiple locations and you have contact with various customers or somebody else within that area, maybe a geographic scope of Georgia or the Southeast or even nationwide can be considered reasonable depending on the facts. And again, with non-solicits, it's maybe a little bit more onerous on the party that signs the non-solicit because those are direct customer relationships and there may be trade secrets with regard to customer lists that are not allowed to be taken. Now, if something's in your mind, how are you going to extract that knowledge of who that former customer was? You can't. So therefore, the restrictive covenant, or pardon me, the non-compete may come into play, or the non-solicit saying, hey, look, you may have the knowledge of these people, but you are not allowed to solicit business from them, possibly even for longer than the non-compete, and certainly with a lot more, or a lot less ambiguity about whether something is reasonable with regard to scope, geographic scope. It's an actual customer, right? So they're readily identifiable.
And then, Mark, these restrictive covenants show up in different contexts, like an employment agreement, maybe a partnership agreement, or the sale of a business. How do those situations differ when it comes to what kinds of restrictions are appropriate?
I mean, it's funny. They're actually very similar in a lot of regards across the you being partners with somebody or an employee or selling a business. It's the more about the scope of what is enforceable. So certainly employees have to be a certain type of employee to have an enforceable restrictive set of restrictive covenants on them. It can't just be like, hey, you're a line cook at at Denny's, and all of a sudden you've got for some reason. I mean, this wouldn't happen, but if you're not a critical person and or a salesperson or somebody that is in a managerial capacity, there's some defined terms within the type of relationship that you have with an employer that would cause you to be subject to a restrictive covenant. A series of restrictive covenants that you sign. I mean, without a signature on an agreement, you as an employee do not have restrictive covenants generally. Trade secrets and things like that might be in play, but not necessarily an obligation to not compete. So, but the term of years and the geographic scope can be a lot more limited, or should be a lot more limited for an employee, as opposed to possibly an independent contractor who is running their own business, or most certainly, partnership you've got a common business and ownership, through, and when I say partnership, it'd probably be members in an LLC or shareholders within a small corporation. There may be more restrictions there that are permissible under case law, and limited on the statute. And then the sale of a business is the most onerous. If you sell a business and somebody's paying you a significant premium for the customer list, the setup of employees, the goodwill of the company, etc., you are selling that. Part of the value that you're getting from that business as a seller is all of the things that the purchaser is buying. And so they want to make sure that they've got long-dated non-competes. 5 years is reasonable versus 2 years in an employment situation. And geographic scope could be pretty much whatever the parties want without it being just overly reaching, because this is a business decision made by a seller. It's not an inequitable power structure of an employer-employee.
And then when someone believes that a restrictive covenant has been violated, what does the enforcement process typically look like, and how quickly can those disputes escalate?
Uh, i- if let's say it's an employer, and just anybody who has the rights under the restrictive covenant to enforce it, it can be very rapid, and sometimes in an emergency, it might even be without the other party even being able to respond in a temporary restraining order. That's an injunctive relief. Most of these documents have rights for injunctive relief. Injunctive is an equitable remedy, or an injunction is an equitable remedy, and there are multiple stages of that. It would be a temporary restraining order, then a temporary injunction, and then a permanent injunction, depending on what stage you go through. You need to be able to present the court with facts to where there's a reasonable likelihood of success on the merits. So you need to be able to, you can't just go in there and say, geez, this guy went to work for a competitor, and then think that that's a slam dunk and you're going to be able to get injunctive relief. You've got to be able to show that based upon the documents and based upon the facts as presented through evidence, that there is a reasonable likelihood of success on the merits of a breach of that restrictive covenants agreement in the future, and that the remedies would not be adequate without, if the passage of time is allowed to occur before you spend 6 months or a year litigating the matter. And if this person is still working with your competitor, maybe you would be permanently impaired as the party with the rights. And so injunctive relief is one aspect of it, but then ultimately you end up having to, have a trial on the case and determine what the damages and liability might be. And again, injunctive relief is forcing somebody to not do something. So the standard's pretty high.
We're talking about a lot of facts, and I know there's a lot of different nuances to each of these, but could you actually share an example where we can tie this together for folks? An example where a restrictive covenant, either well-written or poorly structured, had a significant impact on how a business dispute played out?
Yeah, I mean, and I don't do injunctive relief work. That's pretty specialized. There are firms that really focus on that, or specific professionals. So I do a lot of workouts with regard to partnership disputes, that being also with LLCs, and just general business disputes that get worked out, and sometimes end in litigation, but not necessarily injunctive relief. If somebody's got a problem that I can't handle, I'll refer them out to somebody that needs that can do the injunctive relief work. So, long story short, as far as an example, again, these are fact-intensive matters, and so to the extent that somebody hires somebody for a job, it happens in small business a lot, and then that let's say it's even a mom and pop, and then somebody has their employee has the keys to the kingdom. They have every bit of knowledge across every aspect of the business, and then they go out and hang out their own shingle to compete directly against them. The reasonableness of it's got to be the right type of employee under the statute, and there are significant criteria that it takes too long to go through for this format. And then they have to have a proper geographic restriction, and then ultimately the facts are going to dictate on Was there a violation of a non-compete or non-solicit? Were employees of the employer solicited to come with the employee that left? All those things can come into play, and the language is just, it's just very fact specific. The language is very common and standard, pretty standard. And then the definition of the business matters. The geographic scope needs to be reasonable based upon the type of business that it is and where that business has activity. So the language itself is usually not the problem. It's assuming a professional lawyer drafted it. It's the presenting the facts as they are to apply it to the language and the Restrictive Covenants Act and the Georgia Code. So, but the first thing I ever worked on in 1993 when I was an intern at a law firm was a restrictive covenant matter dealing with a sales team that left. And, this was back in the 90s before the internet and everything else. And so they were talking about phone books, about the dispute of, whether customer lists were taken. And they're like, look, is the whole phone book off limits to my guy now? And this was before the Restrictive Covenants Act. So these things get into, super fact intensive. And if there is an emergency relief, on equitable relief under an injunction or temporary restraining order sought, then it is a wildfire of activity. And there's witnesses and swearing, both probably pejoratives as well as truly swearing in. And they get nasty because it's usually people with tight relationships that one person is trying to take advantage of the other.
So, Mark, for someone who's reviewing a contract that includes a non-compete or similar restriction, what part of the clause deserves the most careful attention before signing?
Well, so there will, if it's done on a, kind of industry standard, there will be a restrictive covenants section. So each one of these is going to have a different component. There will be confidentiality, and that's usually, hey, look, you're allowed to share this information only if a court orders it, or you're allowed to share certain information with your legal or accounting professionals, depending on the nature of the agreement. And again, as I said in the last question, these things are a bit standardized. Certainly, they need to be customized for a particular business, so there's reasonableness associated with it, and evaluating which employees are required to sign and/or which covenants are or which employees can be subject to a non-compete matters. And again, it has to do with managerial control, salespeople, people with executive backgrounds, things like that, not just a secretary. So the all these conditions are going to be somewhat standardized language that is then customized to the particular business and situation. And geographic scope matters, time matters, and the type of transaction it is matters. If it's a sale of a business, you can have more strict rules. If it's an employer-employee relationship, be careful, because the court will not necessarily strike everything, but they will blue pencil it down. They will, if they find it to be egregious, they will. Blue penciling just means crossing out a particular term and then modifying it to something that's more just and appropriate given the fact pattern and the code and case law.
Mark, I think that's where we'll leave it today. Thank you so much for your guidance on non-competes and restrictive covenants. Folks, that's it for today's episode of Atlanta Business and Commercial Real Estate Podcast. If you have questions about restrictive covenants, non-compete agreements, or protecting your business relationship, you can visit battlesonlaw.com to connect with Mark. Thanks for listening, and be sure to like, subscribe, and leave a review so you don't miss the next episode. We'll see you then.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.